Thank you, Senator. Dr. Munger.
Thank you. Sam Blakesley has outlined the problems that the California Legislature Transparency Act is to address. I will break my remarks into three sections in increasing order of detail. First, I will say our broad policy objectives, then the particular means we've chosen to try to implement those objectives, and then as needed, I will get down to choices of specific language, legal aspects, and so forth. We note from the beginning that the whole act, the whole initiative, consists of 2 short paragraphs to be added to the California Constitution and 2 lines in statute. This really isn't all that much to go over. Broad policy objectives. There are 4. 1, to ensure that no bill may pass out of the Assembly or out of the Senate without all of the members of the House passing the bill having had 72 hours to read the language of the bill, for citizens to read the bill and confer with those representatives, and for the members to prepare a thoughtful position of support or opposition or to draft amendments to offer to improve the bill. Second policy position is to require that of any proceeding of this legislature to which a member of the public has a right to attend, that the legislature make and post on the internet an audiovisual recording that any person may see at will. 3, to require that a person attending a proceeding of this legislature that a member of the public has a right to attend, has a right to their own recording of what their eyes see and what their ears hear. Not the official recording where the camera may be in one direction or the other, but what they hear and what they see. The last policy objective is to ensure that the recordings, by whomsoever made, may be freely copied, excerpted, and shared, so that the citizens have the widest access to the information and the widest ability to engage in a discussion of what the legislature, which they, the people, created, is doing and will do for them. Now, at this moment, I'd like to pause briefly and just ask, since our measure has been before the public and this body for over 8 months, does any member present have any objection to these broad policies, that I may respond to that objection in the course of my remarks?
I think one of the concerns that we discussed last week was about kind of cost issues and trying to make sure that we don't have a chilling effect. I know we discussed a little bit last week, but not have a chilling effect on hearings in the field. So I know that was one of the concerns that was there.
Certainly. Is there another that I can address in the context of my remarks?
And then I'm going to want to go through all the ambiguities that were cited by the LAO.
That's fine. As I said, I will go through legal issues and so forth in the third section of my talk, and I will issue the same
fantastic
offer at that time.
But can I just also,
Yep, absolutely.
It was my understanding that this was supposed to be a listening session, and so I think it's really, my understanding is, at least for my purpose, is that I'm hearing the presentation, I'm taking some notes, formulating opinions that may not be completely formulated in the context of your presentation, but it doesn't mean that I won't have questions later on. So just because I don't have any now doesn't mean that I reserve the right to have them later.
Certainly. This is a public hearing. We're here. You're my legislature. This is your opportunity to ask me. I'm here. All right. Now, it will not surprise this legislature that a very large coalition supports these generally common sense policies, and the California Legislature Transparency Act in particular. Specifically, the actual initiative has been formally endorsed by a wide range of organizations who are not usually found on the same side of anything, but here they go. The League of Women Voters of California, the California State Conference of the NAACP, California Common Cause, Californians Aware, the First Amendment Coalition, California Forward, the California Chamber of Commerce, the California Black Chamber of Commerce, the California Business Roundtable, the National Federation of Independent Business of California, La Raza Roundtable de California, the Latin Business Association of California, the Hispanic 100, the Howard Jarvis Taxpayers Association, the Small Business Action Committee, the Los Angeles Chamber of Commerce, the San Francisco Chamber of Commerce, the Fresno Chamber of Commerce, San Jose Silicon Valley chapter of the NAACP, Monterey County Business Council, Valet Contractors Exchange, the R Street Institute. And I will say that this measure is not even qualified for the ballot yet. It will qualify in days, but it's a remarkable coalition which has been assembled in support not only of the policies, but of the specific language and specific measure that we are bringing to the ballot. So I will now proceed to the matters of the implementation. 72 hours notice. At present, the Constitution requires that a bill must be printed and distributed to the members of a House of the Legislature before a vote to pass the bill out of that House may occur. We add to the Constitution a provision that the text of a bill must be posted on the Internet and that the House must wait 72 hours after all three of these requirements are met before it may vote on the bill. That's where the public gets the right to read the bill and confer with their representative, and the representative gets 72 hours to read it. There is an exception in the case of an emergency so dire, where delaying even that 72 hours would not be in the public interest. The governor must declare the emergency. The governor must certify to whichever House proposes to take up the bill that the passage of that particular bill is needed without waiting 72 hours in order to address that emergency. And then the House, by a roll call vote requiring a 2/3 majority, must agree. Immediately after that, the vote to pass the bill in question may proceed. The 2/3 requirement to waive the notice is not onerous because for a bill to take effect instantly after passage, instead of having to wait to take effect until the following January 1, as is typical of ordinary legislation, the bill must be crafted as an urgency statute, which itself requires a 2/3 vote. If 2/3 of the House want to pass it, if it's a good idea to waive the notice requirement, 2/3 of the House will be able to say, we want to waive the notice requirement. The 72-hour notice requirement is enforced by providing in the Constitution that if a vote occurs where the notice is violated, that the bill in question shall not become a statute. Basically, the Supreme Court will toss it, just as the Supreme Court would if the bill were proven now not in fact to have mustered the required majority in the House, in one or other House, or any other constitutional provision about the passage of a bill. Of course, the legislature could always, while the court is mulling over this, simply revisit the bill with due notice and pass it, ending the objection. But if they did not, then the bill would not become a statute. It might take definitive evidence for the court to be convinced that a violation occurred. But because our act mandates the legislature has a constitutional responsibility to record all its public meetings, in particular the one where the language of a bill was last changed, and the one where the House actually moved to vote on that language, that evidence to the court will be available. Even if the official cameras go dark at the critical moment, which under the stress of this and that might happen, by accident or design, because our act provides that any person present may make their own recording of the proceedings, there will be a backup. So that is how the notice requirement is enforced. We now move on to the question of the legislature's recordings. We require the legislature not only make a recording of its public proceedings, but to post it on the Internet within 24 hours. We provide that it must be downloadable, meaning that any person may keep their own copy, and we provide that any person may freely broadcast or otherwise transmit them. Next point. To require that a person attending a proceeding of this legislature has the right, that a member of the public has a right to attend, has therefore a right to their own recording of what their own eyes see and their own ears hear, we provide a measure taken from the Ralph M. Brown and Bagley Keene Open Meeting Act. Those acts, as you know, have been in force for decades, and for every single agency of local government, city council, school board, county board of supervisors, everything, and every single agency of state government except the Assembly and Senate alone. A member of the public who comes into a public meeting may freely make their own record of what they see. That exception for the Assembly and Senate is long overdue to be ended. These recordings under the Brown Act and Bagley-Keene Act provide that the official recordings made are complete, that they stay honest, that there is redundancy in the availability of recordings available to the public, and this is all done at absolutely no cost to the state whatsoever, because these are these people's own recording devices. In the context of our act, while we require the state to post its recordings only within 24 hours, we're not going to ask you to do anything fancy like guaranteeing live streaming of everything instantly. However, recordings by persons of the press, since they're their recordings, may be posted immediately and in fact live streamed. So whether this body chooses to live stream its meetings, information on many meetings will be made available to the public immediately. Now, adapting provisions from the Bagley-Keene Act, the legislature, while it must allow persons to record its public proceedings, may adopt reasonable rules for the sole purpose of ensuring that any disruption of its proceedings is minimized. Now, naturally, to keep the legislature from abusing those rules, we provide two forms of relief to a person whose right to make a recording is being abridged. Specifically, a person may seek a court to grant injunctive relief, meaning the legislature make a rule, and the person wants that rule struck. In the more complicated case of a rule whose future effect in practice on a person seeking to record a meeting is frankly not at all clear, a person may seek from a court declarative relief, that is, to have the court issue a clarification of just what under the rule the legislature is and is not permitted to do in the name of minimizing the disruption of its meetings. In these proceedings, the legislature bears the burden of showing that the purpose of the rule is in fact to minimize the disruption of its proceedings, not to stifle rights of public recording, and that limited end, the rule in question must be, quote, reasonable, end quote, and these are high standards of proof. Last point. To allow the fullest distribution of the recordings, whether made by this legislature or made by a private person, we mention that the recordings by persons may be freely broadcast and transmitted, in whole or in part, that the recordings made by the legislature must be posted on the internet and downloadable for a period of 20 years, and thereafter archived, and all recordings of whatever origin may be used for, quote, any legitimate purpose without imposition of any fee by the state. As for legitimate purpose, you may know that the provisions of an initiative put in statute can be made that it takes a vote of the people to change them. Most statutes by the legislature, in fact, statutes by the legislature, a vote of the legislature may change. That protection is, that word legitimate is protected by the 2/3 required to have another initiative. And consequently, when someone asks what is legitimate, it will be, broadly speaking, legitimate within the purposes of the Act. And we have a page and a half abundantly declaring that the purpose of the Act is to provide public access to information, to allow the public to engage fully in the political process, to allow the public to engage with their representatives before a vote on the bill, et cetera, et cetera. Infringement on that would not be legitimate in the course of, in my view, in the course of any ambiguity or difficulty in someone interpreting it. Now that concludes my part of the talk on the, almost. I want to address a question Mr. Cooley raised and that Mr. Ben Allen raised, including costs of this measure. The first matter is, of course, modern audiovisual recordings are digital files. Digital file is a collection of binary bits. It's 0 and 1s. It's the same file if it was recorded on any media whatsoever. So if we have recorded it on an old-fashioned tape deck, I wouldn't recommend it. And you said, whoops, we want to make it available to the public, but we don't use that technology anymore. You just need to copy the bits over. And there are many services that will exist to do that whenever it's required. To give an example, we used to take color slides. Anyone remember color slides? And there are commercial companies that will take your color slides and they'll turn them into modern computer bit files. They've invented that technology. The transition will be seamless It's not costly. You're not going to be stuck with saying, I've got 20-year-old equipment, which I somehow have to keep maintaining for the business. The purpose of the public having access to these recordings, you can copy the files over as long as they are viewable as audio-visual files by the public, you're good. So legacy issues and equipment are not a major issue. Regarding the question that Mr. Ben Allen asked about the funding of this measure, we did take the cost of this and require them to come from the legislature's own budget. So members of the legislature are aware your budget is tied to something called the state appropriations limit, which is a constitutional limit established by Proposition 140 in 1990, and it's indexed to, if I can remember the technical term, which is eluding me at the moment, but roughly speaking, it goes up as the state economy goes up. As you may also know, that budget in real terms went up 5% last year, 5% this year, and we project it'll go up 5% next year. In fact, I just saw a headline this morning saying that California had suddenly gotten back to being the 6th most powerful economy in the world. And so I think you're going to get your 5%. In real terms, that's something like $40 million a year, and that's a permanent increase in the legislature's budget. We generally agree with the legislative analysts' estimates of the one-time capital costs of this, of $1 to $2 million, and the operating costs annually for the whole shooting match of $1 million. I submit to this legislature the public is going to make available to you an extra $45 million a year, that peeling off $1 million of it, or about 2.5%, to take what you were already doing, you are audiovisual recording and streaming this meeting now, that you take that part of your duties and increase its effectiveness in the same way that you increased effectiveness of the rest of your organization. We do not view that as a big bite out of that increase. And we also think that consolidating the authority for making the videos with the money to make the videos is appropriate public policy. It is the legislature that has authority over the building, over the cameras. It's the legislature to be given the constitutional responsibility for making these recordings. The Constitution now guarantees that you have a budget to do this. It seems an entirely appropriate way for us to do this. We will certainly concede if the costs of this had been $10 million a year, $50 million a year, but at $1 million a year, it's irrelevant. The other matter is you asked the question about the cost of maintaining all of this stuff on the internet. Memory is incredibly cheap and falling ever faster. So if you consult a company like Granicus, or if you consult basically anybody, you will come up with the following remarkable fact. To host all the video that you will record in every public meeting of the legislature over a year, you will spend less money than it will cost you to buy the paper to print the 120 copies the members of the legislature use when they actually go to the floor and vote. It's that cheap. You're talking, it is irrelevant on the scale of a legislature budget, which is currently in the vicinity of $300 million a year. At this point, you're literally legislating over paper clips, relatively speaking.
Well, just if I may, I wasn't asking about the storage. It was more the question of if technology changes, so we have to go back. I think the point is well made. This isn't to the extent that this offers accountability, it is accountability that supports the executive branch in its works, the courts in their work, the citizens generally. It is of necessity would happen associated with the legislature's work, but as a broad general government purpose. That accountability would further. Executive branch agencies, to the extent that we are interested in oversight, would be able to look at the record, understand more, particularly what the discussion was when a bill went through. It is accountability scaled up on a different level, but it is a broad governmental sort of thing. So what actually strikes me as very anomalous that for something that has such a pervasive effect on government and supporting all three branches of government and the people, because of course every bill is the people of California do enact as follows, to say that it would come out of a particular account set up 20 years ago just strikes me as it's an anomaly. It is a general government purpose that's being articulated. So I do want to say I jumped in. I wasn't worried about the storage cost. It was if we have to convert old storage to updated things, and it's coming out of that legislative account. It just strikes me as odd that a broad general government purpose we would articulate in the statute and the Constitution that it comes out of a fund that was established before any of this technology really existed. In 1990, we were barely getting to the use of green diode screens in the legislature. We still had IBM Selectrics pervasive in the building. Word processors were in their infancy. The whole technology scheme was different. So that just strikes me as I don't quite understand the rationale for a bill of such broad governmental purpose. Accountability by its very concept is another party, looking at what the law is. So it's everyone who would have an interest in the work product of this branch of government and what was meant, what was understood. So again, I'm sort of with the chair of Senate elections, and that just strikes me as anomalous.
Can I speak just briefly? So if these were videos of the executive branch, or this was a fund that was going to pay for videos of local government, clearly that very broad overarching conversation about why would the legislature's budget cover it certainly be cogent. But we are talking about recordation of this body, just as we pay for this room. This is another form of public access for what happens in the legislature. And currently, about half of the hearings are televised, and the precedent is that it comes out of the legislature's budget. So we're working within A, existing precedent, and B, the purpose and function of these activities are completely consistent with the legislature's role, not the executive branch, not state departments, agencies, or local government.
Yeah. Well, if I may, last November, Speaker Atkins and Rich Gordon conveyed to every member of this body this book dealing with oversight, and to put our institution on the road to more oversight, which is carrying out, I think, the top two primary, the citizens redistricting, the longer terms for members. And in the transmittal letter, their concluding remark is, we encourage you to consider oversight hearings. The administrative branch of government is tasked with implementing public policy that was created by the legislature. So I believe it is unassailable that the work of the committees, the conversations they hold, the understanding events by memberships as they debate issues of public policy, even as your own digital divide. I saw that you have a video that has me in a foster care hearing. Mr. Blakesley, your digital divide thing, a hearing released earlier this year.
You look great.
It's all about what is the legislature's intent. That is actually the raw material. There's the statute and the associated understanding of the legislature in passing that statute. That is the raw material for the work of the executive branch. And the work of oversight is, are they aligned with that? So I would say, again, this initiative does focus on the fundamental interaction of our tripartite system of government, legislature, executive branch, courts. I'm not arguing with so much the recordation. If you want to go to YouTube, I was looking at your YouTube this morning. You go to YouTube and look up California Proposition 20 or California Proposition 21, California Proposition any up to 27, you're going to find that I'm on YouTube talking about ballot measures, because that's, and they will pull up on the first screen. It's not like I got to go searching my name. So I actually believe in access. But again, I just think for something that aspires to have such a broad impact on government generally, to go into the 20-year-old budget and just say this is uniquely a legislative expense is, to me, anomalous. And that's just an observation. And again, I don't disagree that the cost of saving digital stuff per se, it's more if you ever had to translate it into an updated format to meet the requirement of a 20-year access.
I have at least one more point to make, because you had asked the question about details of language and statutory construction.
Yeah, and we've got, so I guess there are 10 ambiguities that were listed out, and it would be great if we could go through them.
Well, I'm happy to do so, but let me preface this. I certainly agree with Honorable Cooley that I think this is a transformational thing. You mentioned recording these and putting them in the internet for 20 years. After all, you all know that if 15 years after a statute passed, somebody doesn't know how it applies, one of the things courts do is say, what did the legislature have in mind when it passed this? Well, I think they're going to need to look at an archive of recordings to go find out what the members here might have argued at the time. At the present, a lot of that in the committees and so forth evaporates into the air. It's actually important for the legislature to be able to have that on the record so that its own intent is remembered, even if a future legislature might construe a statute differently in trying to enforce it. We've tried to be as respectful of the tripartite nature of our government in this matter as possible. We have a budget that the Constitution actually gives to the legislature to run its operations. We have not deigned to say that anybody else should have authority over a budget that affects something so intimately as the camera arrangements in your own committee rooms. You make the rules for the access to this building. You make the rules for its security. You make the rules for the conduct of your business. To give the authority over funding this to some other agency seemed to us, one, constitutionally perhaps inappropriate and certainly contrary to all existing precedent. We're extending what you are doing and how you're paying for it. Regarding your question about it's anomalous, yes, in this sense it's anomalous. We're saying your proceedings, you have the responsibility to record. Every other agency of government, you are the legislature, and if you want to set recording requirements and pay for them however they're done. You can require local governments to do it by statute. You can do the general fund. You can do anything you want. We're just saying for your unique recordings, your responsibility, your budget, it's your building. You take care of it. It's possible to disagree on that one. We tried to be very careful about it. Let me turn to your issues. In drafting this California Legislature Transparency Act, let me remark that our chief counsel in drafting it is the Honorable Dan Kolke. Mr. Kolke served as the chief legal advisor to Governor Wilson during the 8 years of that administration. He is a former appellate court judge. He was my counsel in the drafting of California's congressional redistricting reform. By the way, thank you for saying kind words about redistricting. Congressional redistricting was something that I essentially carried, and it's nice to know that after the fact. Yeah, it's a pleasure. It's apt to mention this congressional redistricting in particular because there was an alleged ambiguity in the interpretation of the statute that was brought to the California Supreme Court, ironically by my own political party. I fought them. It was dismissed 7-0 within 24 hours of receipt by that court. That measure is also received an indirect challenge before the U.S. Supreme Court as late as last year. Now, Mr. Kolke is, in my view, one of, if not the foremost constitutional scholars and practitioners in the state. And because I'm a conscious man, I had all this work nonetheless reviewed independently by two other attorneys. So while at this late date, this language has been before you for 8 months, it's nice to get feedback from the Legislative Council yesterday at 1:30 about various ambiguities, and just in time for me to spend the interval of time, maybe 18 or 20 hours, trying to respond to your comments. But we're here trying to establish 72 hours for people to take complicated questions and actually think about them before giving answers. So if you'll excuse me, I'm not going to give you definitive answers to your questions. My chief legal counsel is frankly not available for this meeting. This meeting was called on Friday. He's in trial, and he has other clients, so I'm sorry he can't address you directly. Now, if you did mention Ledge Counsel had many specific remarks. Before I go through those in specific, again, are those the only issues that this body currently this has been before you for 8 months? If there's any other issue other than what's raised by Ledge Counsel, this would be a good time to tell us because we would like to respond to you. In particular, if there's any, we would like to take the Ledge Counsel's remarks and we would like to reply in due course. Perhaps a little more than 72 hours would be nice, but anyway, to write a reply and have it appended as part of the official records of this meeting. Would that be acceptable to the body in addition to my answering your questions as best as I can here?
It seems reasonable to me. I mean,
Okay.
But if you do have comments on, this is I understand, you haven't had that much time. But if you do have comments that you'd like to make today on these 10 ambiguities that have been listed out, we would certainly be interested in hearing them.
As I say, we can't give definitive answers on this kind of notice, but on some of these matters we can. Perhaps you would like to look at the list of 10 or so and say which ones you would like me to address first, as you think are the most important. And meanwhile, I'd like to invite Tom Hiltack, who's one of the attorneys on the measure, to join us here. He may be able to address some of your responses directly and somewhat more authoritatively than I could.
Can I just ask a question? And this is not really a question for those who are presenting, because I appreciate the questions that are laid out before us and before you that have been identified by legislative analysts. I have staff who are watching, who are in the office, who are watching from the audience, and there may be questions that, I mean, we certainly would be timely in trying to add those too, and it would be really, I'm just saying through the chair, if I have any questions in a timely enough way that can be presented through the chair and then presented to all of you who may need to have them to respond to. I think that just in terms of process, because I know you've now twice asked for any questions from us here, and I don't want to let that moment pass without again saying that if I don't have a question at this particular moment, does not mean that I will not have a question, but I will respect the fact that being timely and presenting my questions to the chair and then to you, I'll honor that. But just because I'm silent at this particular moment does not necessarily mean that I don't have some questions that might come up after this hearing.